Good afternoon and welcome to the Law and Crime Trial Network. I'm your host, Brian Buckmire. Now we've got 3 live trials for you, so let's get a quick recap. So here's a quick recap of the pathologist for the defense attorney testifying. I'm joined here today via Skype with Michael Troiano and Latonia Hines. How are you guys doing today?
Excellent. Good morning.
How are you?
Great. So the Rosenbaum case has, at least from an evidentiary standpoint, has come to an end. As you see this case unfold, first to you, Latonia, how are you seeing this potential closing that we're probably going to see in about an hour, hour and a half?
Well, here's the thing. The prosecution has, as they stated, over 500 different exhibits that they used during this trial. And I think the main things that they're going to look at and they're going to show that jury, and I think I would do the same, is you're going to put that up there, the pictures of this child. You're going to put those pictures up there so that it's cemented in their minds that they're not going to have a doubt that the bruising that happened to this child was not accidental, that the only way this could have happened was because of abuse. And those are telling pictures. And I think you're going to see the prosecution going over the physical evidence over and over again, because that's the part that I don't think the defense has really gotten, really did the best job of getting over.
And I would agree. We were listening to some of the testimony, especially with this pathologist, Michael. During the direct, sounds sharp. During the cross-examination, one would think, all right, it's kind of gone back and forth as to who's winning this chess match. But I guess the main question I have is, was there enough, or do you potentially see enough to at least kind of just subside or just a little bit below the threshold of beyond a reasonable doubt? I guess my question is there reasonable doubt here that the defense can hang their hat on?
Well, I mean, the pathologist's testimony is extremely important in this particular case and any case like this, because quite frankly, the only people that were there was the child, and she can't speak for herself, unfortunately. Her parents or foster parents in this situation, who are the defendants, and it really is going to come down to how convincing the jury the jury was based upon this expert testimony. I believe doubt is there, but that's a fickle subject when you go back into that jury room.
Yeah. Let's take another look at what the pathologist said while on the stand testifying for the Rosenbaums. So at least what I'm hearing, and I'll direct this question first to Michael, is maybe speculation. He can't really pinpoint that the injuries are from the parents abusing the child or from the parents trying to resuscitate the child. Again, it leads me to believe, is there enough reasonable doubt here to say, hey, maybe it didn't happen the way the prosecution is saying it did?
Well, yeah, I would agree. It's really coming down to this point of a battle of the experts, if you will. And what the jury's going to go in there and make a determination is, if everybody is speculating in their mind, that should be enough for reasonable doubt. If the state is unable to prove their case and go above and beyond that extremely high burden, then they should render a verdict of not guilty.
And I would agree, on paper, that is absolutely true. But Latonia, often with these cases, when it comes to young children, I mean, the absolute innocent of the innocent, I know that sympathy and empathy are not supposed to be considered when making a decision, but I mean, how can you help but give sympathy? There's got to be someone that's to be punished here. Is that going to weigh heavily on the jury here?
Yeah, and I think here's the thing, too. This is also a common sense case. You have any of those jurors there, and they're going to think to themselves, how many injuries did this child have to be 2 years old? Some things, yes, you can say that happened to a child, but have 22 different types of injuries. As the paramedics stated, there were injuries from the head to the toe of this child. Those are things that are very hard to get around, and I think that Dr. Sperry didn't do necessarily the best job in helping in that. And I think the prosecution did a great job in cross-examining him. They went through his own reasons for having to leave the GBI. They went over things with him where he seemed very cagey. He would also kind of wouldn't remember things very well. And he also had to say that he didn't really, he had to say that he somewhat trained Dr. Deriso, that she had further knowledge than that he didn't have, and that she did an extremely thorough, very thorough, autopsy of this child. So I really thought that the defense needed to have a really strong witness for purposes of medical expert to get over that surrounding evidence that the state had. And I don't know that Dr. Sperry was really that powerful.
So, and I would agree, actually, to both of your statements. I do believe fully that it is a battle of the pathologists, a battle of the doctors. And it seems that the defense might be having theirs already crippled somewhat by the credibility that the prosecution was going to raise. It's going to be very interesting to see what this jury comes back with. Again, we're expecting closing statements at 1 p.m. today. But to hear more about this case and others, you got to come back here, the Law&Crime Trial Network. I think that is a great example of a cross-examination where someone has a vast and maybe even superior knowledge of the subject matter that they're cross-examining about. Latonia, you talked very extensively and very well about how this prosecutor is doing a very good job of being able to pick up the pieces and kind of poke holes and show, hey, this is where there's insufficiency in your testimony, this is your credibility. Is this another example of the prosecutor just kind of proving their case?
Yes, and not only that, they did so much research on this expert. And for those people who, I mean, I'm here in Georgia, but obviously Dr. Sperry worked with the GBI for many, many years. So there's a lot of information about him. And plus with the fact that, you know, how he kind of retired very quickly in 2015. So there's a lot of information that is out there that the prosecutor was able to avail themselves of and make sure that they knew what they were going to be dealing with when they cross-examined him. And I think you also noticed when he did do the cross-examination, he talked about the fact that he had talked to Dr. Sperry several days prior to his actual testimony on the stand. So he was ready. This prosecutor was truly ready to do this cross-examination. As a matter of fact, he was so ready, he probably could have also done the direct so that he was prepared to be able to do the cross of him.
So Michael, you said earlier on this is a battle of the doctors. If that is true, how is this war going so far for the defense attorney?
Well, I believe so far the defense's expert has come off fairly credible, and as was discussed previously, the prosecutor is well versed in this area, whether he was trained previously or done his own independent research, or he had his expert essentially educate him on the process, which happens a lot when you are dealing with experts. You will confer with yours in looking at either cross or direct examination questions that are going to be proposed to the other side. What I thought was going well, at least for the prosecution in regards to his cross-examination, when you put that aside, though, I noticed towards the very end, I believe that the prosecutor sort of handicapped himself by getting a little smart with the defense attorney, or excuse me, with the defense's expert regarding the inability to do these sort of experiments on people and killing them and getting into how it's illegal. I think it went a little bit sideways, and I think the jury potentially could either just wholly ignore it or maybe punish the prosecutor for getting a little out of whack, if you will.
Yeah, I fully agree. And right on for both of you. This is one of the reasons why I love the Law&Crime Network, because it's not just, as Michael and Latonia are pointing out, it's not just the information that's being conveyed, it's also the manner in which it's being conveyed. I mean, sometimes it's a popularity contest. It's about who's doing their job better than the other. And if, as Michael is saying, if he's going off on these tangents and the prosecutor is looking a little bad or odd or awkward, it would stand to reason that maybe the defense attorney has some leg room to run with and maybe make the points that they're going to make. Do you think, at least as we're waiting here at 12:25, only about 35 minutes away from the closing statements, how deep do you think the prosecution is going to go in on this witness in terms of his credibility, the information he gave, and how maybe they're going to say that the jury cannot believe or shouldn't believe his testimony? Latonia.
I'm not really sure. I think what you've got to remember, too, that they did get out is that he agreed for the most part with their expert. And not only that, he knows that expert. He didn't say anything that was really discrediting of her and her knowledge. He just said he had a different opinion. And then he also did other suppositions that they can go into. He's looking at things from a, how would you say this, on from a wall. She's looking at it because she directly did it. And that's different. And the other thing that the prosecution was able to talk about, it's been a very long time since he himself has participated in such a type of autopsy of any sort. because even when he was last at the GBI, he had only participated in 2, I think, during that year. So I think that's something that was that they can kind of go over with him. And I don't think you need to spend tons of time and beating up on him, because I don't think that he really added a lot for purposes of the testimony yesterday. I think that they might have been better served to have had a different expert, where you didn't have to worry about going into some of the history that he had that kind of, taints a little bit his testimony.
Yeah, and so we hear the defense attorneys rested, meaning no more witnesses, no one to testify. And of course, that comes with the defendants not testifying themselves. We hear from experts and family friends and family members who observed their parenting and the children. Michael, do you think that the defendants maybe should have testified in this case, and that would have been a little bit more advantageous for them? Of course, we can't hold it against them, but could it have helped?
Sure. When you present that to the jury that they cannot and should not hold it against them, we all know that they're human beings, and when they go back into that jury room, they may or may not use that against them, regardless of the instruction from the judge. But the fact remains, I explain this to my clients in any case, whether it's very minor or as serious as you can think of. Even if you are wholly, absolutely innocent, getting up on that stand and letting a professional prosecutor pick you apart and question you and turn every tiny little detail that you say into something else can be problematic. So even if they were absolutely, God's honest truth, 100% innocent, it's still a very large risk to put a defendant on the stand when they are open to cross-examination from the prosecutor.
Absolutely, and of course, we love being able to not only educate each other, as I'm learning, but also the audience, that people not testifying can be for any myriad of reasons. It's not just to hide something. It's a very difficult thing to do, even if you're the prosecution's witness being cross-examined by a defense attorney. But we're going to continue with this case and more after this break.